would you say that we love the internal market in the law exam? Yeah, we love it a lot. Okay, there you go. Okay. It is really the European Union manifesto. Whatever you say, yes, there are other important areas, but certainly free movement is what distinguishes the internal market from any other free trade agreements, okay? And I say, unfortunately, the Brexit debate highlights such a big difference. You can have CETA, you can have Japan trade agreement, you can have NAFTA, whatever, you can have the WTO thing, fine, all very respectable free trade agreements, perhaps, but then certainly the internal market is another matter, right? This is really the flagship of the EU, okay? This is the success, this is whatever you say. I mean, again, I'm not trying to make a political point, but it's an amazing story, because in 60 years, such an integrated market, you know, can't think about any other examples, you know, about member states, different sovereign countries getting together to create such a trade area. And again, as you recall, from the very early days, the common market was based on the idea that, A, you should have free circulation on products, services, establishment, capital, and workers, okay? Obviously, with the introduction of the Single European Act, and later on, we moved from the idea of the common market to the internal market, which gives also this extra dimension, this extra hint that we are really dealing with an integrated market where no internal borders are allowed, okay? So the whole idea about the internal market is a very interesting phenomenon, if I can spend one word, because obviously it's mostly about deregulation, right? Because the internal market is about creating conditions which are about to say from 28 trade standards you go down to 1, okay? So that's the point about you need to simplify, you need to cut red tape, you need to create less barriers, you need to remove barriers and stuff like that. So that's why the internal market is based on what we call negative freedoms. That is to say, you member state, you're not entitled to come up with a new barriers. You need to remove those, okay? So again, internal market means trade deregulation, okay? Less rules, from 28 to 1. At the same time, remember, that's also the characteristic of European Union, because not only you ask member states to remove obstacles, so you simplify and deregulate, but at the same time you have European institutions with the power of regulating. So you have deregulation and re-regulation, because once you decide that it's one common standard, then it will be for the European Commission, the European Parliament, the European Council to simply say, okay, we decide that we need to have common standards on toys for children. Okay, we decide this is the standard, okay, which will be embodied in a regulation, in a directive, okay? So you deregulate because you remove national obstacles, and at the same time you give the power to supranational institutions to come up with a new standard regulation. Okay, is that clear? It's quite fine, because that doesn't happen in any other forms of trade integration. The WTO does not have the power to harmonize. You might have some powers to remove obstacles, but you don't have the power to harmonize trade standards, okay? It's a very European phenomenon. Deregulation, re-regulation, okay? You decide to abolish, roaming charges in Europe, it's re-regulation of the market, okay? You decide to abolish advertising for tobacco, it's a regulation of the market, okay? Historically, however, the big push, again, comes from negative harmonization. That is to say, prohibition on member states. And again, big push, European Court of Justice. Again, even the internal market, before all the political changes, before the 92 programs with the Commission passed new legislation, big starting point, Luxembourg Court, once again. Now, what I'm going to do is to try, A, to recap why the internal market, as sketched by the court, is such an important issue, and then we'll flash a few bits and pieces. Now, a practical point. As you know, the European Court of Justice likes to deal with one freedom at a time, right? So obviously, the treaty says free movement of goods, services, establishment, capital, and workers. And the European Court of Justice is quite formalistic on this. You know, usually one case is treated under one freedom, okay? So that's And again, I'm going to be really direct. Obviously, exam question will need to be replied using the European Court of Justice attitude. You might have cases which they might seem a little bit on the border. You will have to decide which freedom applies, because generally speaking, the court likes to deal with one freedom. There are different articles which are applicable to each freedom, the different justification which are applicable to freedom. So remember, that's a general advice. You need to decide under which freedom you're going to deal with it, okay? Because obviously one is Article 34, one is 59, whatever, okay? That's clear. However, what I'm trying to say now is that in reality, the court, over 50 years and plus of case law, has developed some general principles which are applicable to all freedoms, okay? So I'm going to speak a little bit more on goods and services in general. You have in your mind that obviously you will have to go for one specific freedoms, but remember, the principles are exactly the same. And actually, nothing prevents you, like the court does, also to get inspiration from other freedoms, okay? So let's say in an exam question you decide that it's a goods question, but it's not a mistake to simply say, as the court said in the field of services, blah, 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 okay? Is that clear? That was a practical point, okay? So remember, I'm talking in general, but, you know, this principle that can be transplanted from one to another, okay? More or less, even service and establishment now they're the same thing, okay? Now, the most important judgment, the only one that you really need to understand, you need to, is like at the same level of Van Genden Costa and Van Genden Costa, sorry, Van Genden Loss and Costa, okay, it's Dastonville, okay? Now, why is it Dastonville? I didn't put it here. Now remember, 1974 is the only judgment that you need to remember. Once you understand Dastonville, you're done. So let me recap once again. What was the problem there? Do you remember? Remember, the internal market is based on drinks. Yes. More than licensing.
Well, they couldn't get the licenses they needed.
Why?
It had already been imported into France.
It was important, remember, whiskey coming from the UK into France, trying to export it to Belgium, and why they ran into trouble in particular. Do you remember? They missed one point. It was remember, this Dastonville was a family-run company, which basically what they did was to import the bottle without labels. And they put their own labels, nice one, you know, with the French, nice little thing. But they missed one. What were they missing? Sorry.
Belgium wanted the Scottish licenses.
Okay. They got what they want to say. Where does it come from? It's not clear from your bottles where this whiskey comes from. So we want to have a certificate of origin, okay? You don't have it, it's a criminal case, remember. It's against Dastonville. So they actually say, we're going to fine you because you don't have that certificate of origin, okay? So the case was whether this measure could be classified as an obstacle to trade, and in particular, whether there was a violation of Article 34 of the treaty, and in particular, whether this could be classified as a measure having equivalent effect to a quota. Remember, Article 34 is a 1950 article, okay? It's very WTO style. Article 34, I remind you, says quota, and a quota in trade law is what? Okay, it's a quantity restriction, right? Okay, quantity restriction, like you cannot import more than 100 bottles, a ban, okay? You know, the treaty says quantity restriction, quotas, and measures having equivalent effect to quotas are prohibited, right? So it's a classic 1957 definition, that is to say that trade is about removing quotas, or measure which have the equivalent effect of a quota. Now, Dastonville, again, sorry to remind you about this very basic case, but would you say that we're dealing with a quota? No. Are we dealing with a measure which has the same effect as a quota, strictly speaking? You know, it's a piece of paper, right? Because, did the Belgian authority have any problems about the content in itself? And they simply say, look, you give me this certificate, you're fine. So is it strictly speaking a quota or a ban? But then, is it a nuisance, is it a hindrance?
Yeah, it's an obstacle.
It's an obstacle. Okay. So, first of all, and again, that was the opportunity the court was waiting for, right? And again, the court could have gone for a very nice